Saleh, Musa and Ahok are the shareholders of Usaha Sama Sendirian Berhad. Saleh holds the majority of share in the company. He was appointed as a director to manage the company as he had the expertise in the business run by the company. He was then diagnosed with bone cancer at stage 4. Due to his illness, Saleh had entered into a contract with the company for the payment of pension to his wife, Sophia. After his death, as Sophia is a full-time housewife and she has no source of income. After Saleh's death, Sophia claimed for the payment of pension from the company. Musa and Ahok objected to the claim on the ground that Saleh had breached his duty as a director.
The main issue in this case is whether Saleh breached his duty as a director by entering into contract for the payment of pension to his wife Sophia without the consent of other shareholders, Musa and Ahok. Second issue for this case is whether Musa and Ahok can reject Sophia's claim of pension. I will explain about duty of director under Section 213 of Company Act 2016, which focusing on the obligation to act in the best interest of the company. Under Section 213, it explains that director must always put the needs of the company ahead their own benefit once they have power. To make sure this happens, director need to use both experience and information, which always aware about their own agreement before become a director. This section can be illustrated with the case Tengku Datuk Ibrahim Petra Tengku Indra versus Petra Perdana Berhad and another appeal. Case highlight the important director duties related to honesty and reasonable. Director should focus more about company than himself in order to gain trust among company members. Another case can be illustrated for this section is Hawk versus Crampon Limited 1967. It shows director must do well in their work. They must do what right for company and in good faith. The power director has must fit the action they do. If they break their duty, automatically will break their right obligation.
Next, I'm going to talk about Section 221 of the Company Act 2016, Section 218 in bracket 1 of the Company Act 2016, Section 221 in bracket 10 and Section 21 in bracket 1. For the Section 221 of the Company Act 2016, it requires the director to disclose any interest they have in the contract or proposed contract with the company, either directly or indirectly. Again, we can see this from the case Tiao Chuan versus Tunku Nasaruddin Ibn Dafa. From this case, as a director must inform the board about any personal interest in company transaction. If not, the director automatically breach the contract. Organic for the Section 218 in bracket 1 of the Company Act 2016, it explains that it can accompany the director and officer to take use of its opportunities, knowledge, or property without first getting the shareholder consent in public meeting, its provisions, and to prevent director and officer from using their position for personal gain at the expense of the company. For the Section 221 in bracket 10, it stated that a contract entered into in contravention of this section shall be voidable at the instance of the company except if it's in a favor of any person dealing with the company for any valuable consideration and without any actual notice of intervention. And the last one, for the Section 21 in bracket 1, the company is capable of exercising all functions of the body component, including right to sue or being sued on its own behalf.
In determining whether Saleh had breached his duty as a director, we can look at three sections in Company Act 2016. Saleh, a director of Usaha Sama SDN BHT, and had signed a contract of pension contract for his force. This action breach Section 213 as a director are required to utilize their authority in good faith and for the right reason, always acting in the company's best interest. Saleh, utilizing his position of director to sign such a contract is also considered as a breach in section 218 bracket 1, as the section explains that it is against company directors and officers to use its position as such director or officer to gain directly and or indirectly a benefit for himself or any other person or cause detriment to the company. Saleh signing such a contract with personal interests involved but not disclosing it are a breach of Section 221 of Company Act 2016, where directors are required to disclose any interest they have in a contract or proposed contract with the company, either directly or indirectly. They must declare the nature of their interest at the board meeting as soon as possible after becoming aware of the facts.
Discuss whether Musa and Ahok are able to void the contract of Saleh. Two sections in Company Act 2016 will be considered. First is Section 21(1). So this section implies that company is capable of exercising all functions of a body corporate, including right or sue or being sued by its own name. So Musa and Ahok are unable to void the contract by themselves, but they should hold a meeting to sue Saleh for breaching the duty of director and recover any potential damage due. While Section 21110 stated that the contract entered into in contravention of this section shall be voidable at the instance of the company, except if it is in favor of any person dealing with the company for any valuable consideration and without any actual notice for the contravention. So, since Saleh did not disclose his involvement in interest for this contract, the company can void the contract under Section 22110. So the contract is voidable for the company.
So the conclusion is Saleh breached his duty as a director by failing to act in the best interest of the company and using his position for personal gain. There are three reasons why Saleh breached his duty as a director. The first reason is breach of fiduciary duty. Saleh failed to act in the best interest of the company, used his position for personal gain by arranging a pension for his wife. The second reason is violation of Section 221. Did not disclose his interest in the pension contract, breached transparency and governance requirements. The third reason is contravention of Section 218 Clause 1. Misuse company resource and opportunity without shareholder approval. Take advantage of his position for the personal benefit. The key point of these cases is significant departure from expected standard of director conduct, which align with fiduciary duty principle and statutory requirement in Companies Act 2016, supported by relevant case law including Hawk vs. Cramhorn and Cook vs. Diggs. That's all from us. Thank you.